So Bryant versus Michigan continues our question of what an ongoing situation is that the statements are offered to resolve versus a statement that is offered in anticipation of litigation, such that they would be regarded as testimonial and therefore problematic under the Confrontation Clause. In Bryant versus Michigan, the police show up at a gas station where someone has been fatally shot, and they ask the victim, questions like, who did this, where did this happen, and that sort of thing. These are not statements for medical treatment because, as we know, the statement "who did this," as opposed to "what happened," it doesn't matter who shot you. It's relevant that you were shot for the purposes of medical treatment, so it doesn't come in under that exception. The court says it does, however, come in under, and this is how the trial court analyzed it, that it does come in under an excited utterance. The person's been shot, obviously fatally so. That tends to keep a person amped up. And so the court then says, since it meets the excited utterance question, does it now satisfy the Confrontation Clause? That forces us to ask the question of whether the statement is testimonial or not. And by testimonial, we mean, as we've seen before, does this come in, is this being offered as something that the speaker would reasonably interpret being used in the criminal prosecution, or is this something being used to resolve the ongoing situation? The shooter ran that way, for instance. And the court says, since the shooting was a mere 25 minutes ago, since neither the police nor the victim know where the shooter is, that this statement that identifies the shooter could be intended to help catch the shooter at the moment rather than convict the shooter later. And that's the question we're asking. I mean, let's not make it more complicated than it is, and let's not try to make any more sense of it than it does make. We're asking the question of whether the shooter is identifying or rather whether the victim is identifying the shooter so the police can arrest him, or whether the victim is identifying the shooter so they can convict him. That's the whole question this comes down to. And that was the criminal procedure revolution that Antonin Scalia brought about when he in Crawford versus Washington took us down this turn of asking not what was sufficiently reliable to be regarded as an exception to regarded as sufficiently reliable to satisfy the Confrontation Clause, but rather what procedurally is sufficient for an exception to the Confrontation Clause. And we are asking here, did the poor victim who was laying in the street, did he think that he was giving police essential information so they can catch the guy now or convict him later? And that question is going to determine whether his statement is admissible. So the majority, Justice Sotomayor, says, well, yeah, this was about nabbing him now because no one knew if he was right around the corner. No one knew if he was waiting in the wings, waiting in the bushes to off this guy. Scalia in dissent is just outraged. He says, wait a minute, this makes no sense. You've now stretched my doctrine to where it now no longer means anything, because even Detroit, for all of the bad stories you might hear about Detroit and its crime issues, it's not such a horrible place that when drug deals go bad, the shooters like stalk the people and are willing to shoot them in front of the actual police. That this is not a normal, even for a homicide, that's not something anyone would expect. And so these statements are meant for the purpose of criminal conviction, not for the purpose of identifying and catching this guy who's presenting an ongoing danger to the public. Now, of course, Sotomayor wins, and so now we have a much broader view of what an ongoing danger is. Even if it, as in my mind, the distinction really doesn't what are we trying to do with this distinction? Why does it matter that this guy who's been shot in a gas station or laying in a gas station, shot in Detroit, is thinking about helping the police catch this guy who's right now on the lurch and potentially a danger to other people, versus convicting him and putting him in jail, where this dangerous bad person will go away and not be a danger to people long term. That distinction, to me, doesn't really explain why one statement should be admitted versus the other. But that's the world we have under Crawford versus Washington in this new confrontation clause world. But remember, with all of these, you first have to show a hearsay exception, and then in criminal cases, when used against the defendant, we're asking this extra layer of whether something violates the confrontation clause or not. So, of course, the majority says this is an ongoing situation. This guy could still be out there, could still be posing dangers to other people, or even the victim. One of the really interesting things about this case, though, you may have noticed it in the Crawford case, and certainly in the Michigan versus Bryant case, and maybe even in the Giles case, definitely in the Giles case, the court notes that a dying declaration is absolutely something that we recognize to satisfy the confrontation clause. And here you've got a man shot in a gas station who does die. Why didn't the Michigan prosecutors just offer this as a dying declaration? Because if they had, there would be no question that it would have satisfied the confrontation clause, and we wouldn't be having this question about whether this is about finding the guy who's now dangerous or convicting the guy who's long-term a menace to society. The reason, though, that we're looking at this under excited utterance rather than dying declaration is because that was the theory that the prosecutors offered it under when they prosecuted the case. If they had used dying declaration as the theory for admitting this, then as the court's jurisprudence in this area of kind of confrontation clause has clearly established, there would be no question that it would be admissible as an exception. That dying declarations are always regarded to satisfy concerns about the confrontation clause because of the historical nature of this, according to Scalia in Giles and in Crawford, and then in the majority in Bryant. But because it was offered as an excited utterance, we then have to go through this whole question. Again, the key thing you take away from this is if the police or the statement to the police is designed to resolve an ongoing situation, an ongoing emergency, something society immediately is concerned with, then those statements are not testimonial, and therefore, if they satisfy an exception to hearsay, they will come in consistent with the confrontation clause. If the statements are not being offered to resolve an ongoing situation, those statements are regarded to be matters addressed to a criminal case that will subsequently be heard, and those statements are testimonial, and therefore can only come in by the person who spoke them in court when there is an opportunity for cross-examination.